Okay, so it's a great pleasure to have all these distinguished colleagues here who've been able to join us on short notice for a panel on ethics in data science. We've got Professor Chris Slobogin from our law school is going to talk about data science with regard to policing, sentence recommendation, and so forth. Eugene Vorobeychik is going to talk about data ethics with regard to security, privacy, and so forth. And Professor Sarah Igo from history will be talking again about privacy, and she and I will both be discussing a bit ethics around data, not just in the data that we collect, but also the negative spaces of the data that we don't collect and who doesn't get counted. So without further ado, I'd like to turn this over to Professor Slobogin. Okay.
Thanks. Appreciate it. Good to be here. I'm going to be talking about big data and criminal justice, or more specifically, data collection and use of algorithms and artificial intelligence and the like by the police and by judges and by parole authorities. But I've only got 8 minutes, and maybe even less, depending. So all I'm going to do in talking about these issues is tell you what's out there, what's going on, and let you draw conclusions about what it means and how controversial it is. I will flag that these issues are very topical and very difficult. They have to do with government power, they have to do with privacy, they have to do with equality and discrimination. So, if you find anything I have to say interesting, and of course this isn't working now, I strongly urge you to come to a panel next Friday, which will be on this precise issue, but instead of 8 minutes, it will last 2 hours. It's going to involve 5 panelists, and still doesn't work. It involves 5 panelists, some of whom are law professors, some of whom are computer scientists, and some of whom are psychologists, and they will be talking about the kinds of issues that I'm going to be addressing, I think, right now. It depends on whether I'll be addressing it. So I guess when you switch it out.
Yeah, there we go. You should be able to advance. Somehow we're not getting the synchronization between the two.
We had it before.
Let me go to Zoom slideshow.
There we go.
There we go.
Oh, don't give away all my slides. Okay. So there is the information about next week's panel. You can see the title is very similar to this one. I strongly urge you to come to it if you're all interested in this area. So what am I talking about? Well, if you didn't already know because of the Facebook scandal, you now know that if you're on the internet, companies are accumulating your information all the time. Information about who you communicate with, what you're buying, demographic information, all sorts of other tidbits. Getting off Facebook won't solve the problem. You have to get off the internet to avoid these companies collecting information about you. The interesting aspect of this from the criminal justice perspective is that the government can get a hold of all the information these companies are accumulating without a warrant and in many cases without a court order at all, on the theory that if you surrender information to one of these companies, you assume the risk that those companies will turn it over to the government. So no warrant or court order is needed to obtain a lot of this information you see up here on the screen. So the Facebook scandal is just one example of what's going on in the data accumulation area that might benefit law enforcement. Another recent event, you all know about the Austin serial bomber. You may know that one way he was captured was using camera surveillance and cell phone data. This is something police are doing quite prolifically these days. In Chicago, there are over 2,500 closed-circuit TV cameras, some with night vision capacity, zoom capacity, all feeding information into a $43 million command center. A number of jurisdictions, including Houston, among others, are now using drone cameras that can pick up the numbers on a license plate. Radio frequency identification devices can be placed in cars to tell the government where you are now and where you've been. The police made over 20 million requests to service providers to get location information through these kinds of devices. And also, of course, through your phone. You know, GPS technology can locate you within 15 feet. Police are also starting to use what are called stingrays. These are devices that actually can simulate being a cell tower. That is, they fool your phone into thinking that they are a cell tower, and police can find your location that way as well. No warrants required to get this kind of information, perhaps no court order of any kind. So that's how the police get this information. What do they do with it? Well, police are starting to use algorithms and artificial intelligence to figure out who's worth investigating and who is not. A very primitive kind of program nicknamed the Heat List, was developed by the Chicago Police Department. It looks at arrest records, parole records, gang lists, and so on. It assigns a risk score of from 1 to 500 to the individual. If you have a high score, it's not good. Okay, they're going to subject you to surveillance. A much more sophisticated device developed by a company called Intrado is called Beware. This program purportedly accesses billions of records in all the areas that you see there in mere seconds, and then assigns a risk score to an individual for purposes of helping police investigate. In the counterterrorism era, the government's been even more ambitious. The most famous counterterrorism program some of you may have heard of was called Total Information Awareness. It was developed after 9/11 by the Defense Department. As you can tell from this icon, the Department of Defense is probably not the most adept when it comes to public relations, because not only was the program called Total Information Awareness, as you can see from the icon, it depicts an all-seeing eye looking at the globe, along with the maxim in Latin, knowledge is power. Okay? So what did this do? Well, it collected information from a whole bunch of different sources. I don't know if you can read this. I'll read it for you. Financial records, educational records, travel, medical records, veterinarian records. Who knows what your dog's up to? Housing records, government records, communications records, and so on. Once all this information was accumulated, an algorithm was supposedly applied to figure out who might be a terrorist. This program is so creepy that Congress voted to defund it in 2003. That's extremely unusual for Congress to voice vote on anything, but even Republicans voted to defund this. However, as Edward Snowden made clear, these programs still exist under other names, like Stellar Wind, Matrix, and PRISM. And it's not just in the counterterrorism area that these massive data collection programs are going on. There are now many TIA programs all over the country, more than 80 at last count. They're called fusion centers because they fuse together information from a number of different sources, and they're aimed at domestic investigation, not counterterrorism. So that's a very brief preview of what's going on in the police area. I want to quickly move now to pretrial detention and sentencing. What's going on here? Well, data is being used here through algorithms, statistically derived algorithms that try to figure out who's going to recidivate and who isn't, in order to figure out who should be subjected to pretrial detention, who should get a longer sentence, who should be denied parole. This is an example of one of these risk assessment instruments. It's called the Violence Risk Appraisal Guide, the Violence Risk Appraisal Guide, VRAG. And as you can see, it looks at 12 different risk factors, including the score on the psychopathy checklist, which is obviously a measurement of psychopathy, other kinds of diagnoses, age, some familial matters, and any social activity. The various kinds of point totals you'll see here are summed up, and then people are assigned one of 9 probability bins. So, for instance, if you get a score of 0 to 6, that's associated with a 35% chance of recidivating. If you get a score of 21 to 27, that's associated with a 75% chance of recidivating. Here's another risk assessment instrument called the Oxrisk. It was developed, not surprisingly, by people at Oxford. And it has even more risk factors, including gender, age, immigrant status, a number of factors having to do with antisocial behavior, marital status, educational status, income, a number of factors having to do with disability, and then a very interesting phenomena, something called the neighborhood deprivation score, which is basically an analysis of the offender's neighborhood based on these metrics. So how good is this risk assessment instrument? Well, here is the initial validation study of the Oxrisk, and what it shows is that of those people identified as high risk, about 60% of them recidivated within a 2-year period. Of course, what that means is 40% of the people identified as high risk did not recidivate. So is that a problem? I'm not going to answer that question. Instead, I'm going to ask some more questions, and then I'm going to end. Let's assume the Oxrisk is 100% accurate, that everyone it says is high risk, in fact, recidivates. One could still ask, is it okay to base a lot of the risk factors on aspects of an individual that have nothing to do with blameworthy criminal conduct, that have nothing to do with criminally blameworthy conduct? Is it okay to base the risk factors on factors that have nothing to do with conduct, like gender and age? Is it okay to base these kinds of risk assessments on factors that have nothing to do with the offender at all, which is what the neighborhood deprivation score has to do with? And finally, as you can see from these factors as well as some of the others, another question that could be asked is it okay to base these risk assessments on factors that might be strongly associated with race and class? Well, I've asked a whole bunch of questions. I'm not going to answer any of them. That's what we're doing next Friday. I strongly urge you to come to that panel. You have to register for it because we need to know how many people need lunch. You not only get a great 2-hour discussion, but you get a free lunch. You can't pass it up. So there's the registration information. You can also go online and find out about it. Thank you very much.
Okay, Eugene, would you like? So next we have Professor Eugene Vorobeychik, and here is your thing. Let me see if I can get this started properly.
Yeah. Is this the?
That's going to be the controller. Okay, so. There we go. Okay, so you can use that.
Sure. Let me see. Okay. All right. So that's going to be hard to beat. That was really interesting. I'll touch upon some of the issues that Chris brought up, but not anywhere near the same depth. But the scope of what I'll mention is a bit broader. So, safe, secure, and fair AI. Okay, so everybody knows nowadays data science is easy. It's actually sort of become remarkably easy. Assuming you are relatively adept at picking up programming languages, of course. But the tools have become quite amazing, right? So essentially, you can have a cookbook of doing data science, roughly as follows, right? You learn Python, you find your favorite data set that you want to work with, you fit your model using scikit, which is a Python machine learning library. You do some technique to make sure that your results make sense, like cross-validation and whatnot. And let's just say you got to a point where you have pretty good accuracy, just basically some measure of how well you're doing. Let's say 95% of the time you're doing great. It's tempting to say at that point, I'm done. I'll just push this to practice and have people use it. For example, to make decisions such as predict hospital readmission rates, predict recidivism, which is what Chris was just talking about, predict whether presidential tweets are going to be on a particular topic, whether there's going to be a nuclear war in the next 5 years and whatnot. So that's all great, but what I want to mention is some of the major caveats having to do with doing that sort of stuff without carefully considering what the models are actually doing and how. Okay, and the three things that have come up and have actually raised a lot of red flags of late especially, and have garnered a lot of research attention as well across fields, are safety, security, and fairness. And I use them, all three of them, in fairly broad scope. So safety, things like how do you make your predictions lead to safe behavior? How do you make sure that your autonomous car doesn't drive off a cliff if it's in an environment that hasn't seen before? Okay, but also things like privacy. Is your data your machine learning model going to leak privacy or leak some information about patients, for example, that have been used to train this model? Okay, in security, how do we approach, so suppose that you're using your machine learning models in a high-stakes environment where there could be economic gain or other gain from some malicious parties to mess around with it. Okay, can your approach be compromised for malicious ends? Unfortunately, it turns out to be yes for a great deal more approaches than people should feel comfortable with. And finally, fairness, which touches upon some of the issues with, that Chris was talking about. Does it fairly discriminate against minority groups, or does it, do any, fairly select people, or exclude people and whatnot? Okay, so let me start with safety. Algorithms. One thing to consider all the time is the algorithms and statistics. The way you sort of use them off the shelf, unless you're careful, will focus on typical cases, right? If your data largely is sampled from particular domains, they happen to be most accessible, okay, that's what the model is going to be good for, okay? The complement of that is if you're not sampling sufficiently things that are uncommon, but could lead to disasters, okay, potentially, even if your accuracy is high, you're going to really suck for those things. And unless you're careful, you're going to find out when you fall off the cliff driving in an autonomous car. So unfortunately, unexpected cases can be a real problem. And there have been interesting technologies or ways that people have been starting to explore these unexpected cases that is actually congruent with what I would call also secure. Okay, so it's by introducing adversarial noise. Basically, you design an instance which is kind of adversarially bad in terms of model prediction. So I'll illustrate how this works. So one of the famous examples of this is images that I'm going to show. This image right here is classified by a state-of-the-art deep neural network as a panda. Okay, the citation to the paper, if you're interested in, is below. Okay, you add very small adversarial noise, a particularly crafted noise. Now, it's a lot smaller than it looks. This is amplified so you can see that there's even noise there. Okay, and what you get is an image that looks like this. To us, essentially indistinguishable for the first one, but it's classified with confidence of about 99% as a gibbon, decidedly not panda. Okay, so if you're wondering why people should care about pandas being misclassified as gibbons, maybe not. Okay, but you certainly care about stop signs being misclassified as something like a speed limit sign. And a paper by a bunch of authors, including a former student of mine, showed that by posting things that looks like graffiti, but is actually carefully crafted stickers and stop signs, you can essentially make it look to a state-of-the-art deep neural network as if it's a something else, like in this case, a speed limit sign, which I think is a great deal more scary unless you're careful. Okay, something that we've been doing recently is looking at the same kind of phenomena of unexpected perturbations, again, adversarially crafted, in medical imaging. So here you have examples of MRIs of people's brains. The goal here is sort of a benign-looking goal of predicting age. Suggestion of our results would be that this could raise some major ethical concerns if there were an issue with things that predict other things like phenotypes, right? So what you see on the upper left-hand corner is a model that takes the MRI image of a particular brain and predicts age of 19, which is basically accurate, plus or minus like 0.1. Okay, so what we did is we perturbed this image of the brain to get what you see in the lower right-hand corner, that's the plus noise. Okay, the first thing that you should notice is nothing, which is that those two images should look to you presumably almost identical and to anybody else. Okay, and the second thing you should notice is the prediction below that, which is now it's being predicted as 80 years old. So it's sort of, again, remarkable. You have these fairly well-performing models. You can add a little bit of noise that nobody can notice. That will basically result in completely wrong predictions. Completely wrong, not even slightly wrong. Okay? And that should be somewhat disturbing. Okay, so how can machine learning compromise privacy? So certain models in machine learning actually include inside the model a portion of a data set. And the size of the portion, unless you're careful, could be fairly large. Okay, so one common model that has historically performed extremely well is called support vector machines. In this case, I'm going to talk about the nonlinear support vector machine, or SVM. If you don't know what it is, don't worry about it. What you need to know is that a nonlinear SVM, in order to make predictions, need to carry around with it what are called support vectors, basically parts of your data set. Okay, now in a good model, those parts should be sort of very small in proportion to data set. But if you're not careful, you can carry around a decent chunk of it. And in any case, you are carrying around actual data points. Now, data points, if you're learning something about patients and trying to predict, your model predicts things about patients and clinical records, now you potentially are compromising that information to the public if you're opening this up to the public. So something of a concern. This comes up not just in SVMs, but in other domains. Sometimes it's a bit more subtle than this. This is about as overt an example as you can get. Okay, so fairness and bias has been now recognized as a major issue with algorithms and machine learning, actually models that people have learned, including things like recidivism, where there's bias, particularly against certain groups. Okay, and there are a number of reasons for getting this bias. Some of it is that the data itself is biased. Some of it has to do with the fact that it's tempting to use simplistic measures of goodness of fit, like accuracy, which for anything that is going to determine policy decisions is plainly wrong thing to do, because accuracy can be deceivingly good for a million reasons. And it would allow you to ignore things that are actually significant, which is what happens a fair bit. Okay, and essentially accuracy, if you don't like, there's other single-dimensional measures, but I would argue for any such single-dimensional measure, there's going to be some problem you're going to not detect. So essentially the point here is that you need to look at deeper measures of effectiveness for machine learning algorithms if you're going to use them in practice, rather than just some simplistic things like that. Okay? But there are many other things that can go wrong, and I'm just going to give kind of completely made-up illustrations. Some of the other things that can go wrong if you're not careful about the kinds of models you're using and what those models essentially assume about the world. And every model assumes something about the world that can be important in predicting things. So here is a data set that I completely made up just to illustrate a point. Okay, it's just predicting recidivism as a function of income. And I'm thinking of recidivism here, you'll notice, as a real value. Don't worry about the fact that it's not really. okay, but let's just say a measure of risk of recidivism or something like that. So here's your data, right? If you fit the line to it, it'll look something like this, which seems perfectly reasonable given this data set, okay? And you would say, okay, so those 3 points right there look sort of like outliers, who cares? Okay, fine. Okay, but let's pretend that those 3 points are not just outliers, but they happen to be members of a completely different group. So now you have the x's, which are group 1, and the zeros that are group 2. Now it hopefully is apparent what could go wrong, right? So look at the difference between the points. You're obviously overestimating recidivism for group 2 by just throwing plain statistics at it. Okay, and a part of the problem here that I'm trying to highlight is that because you're not distinguishing those groups and the relationship as a function of these variables is qualitatively different from the two, you're basically screwing the second group. Okay, now it's tempting to suggest, okay, so a simple fix is to split up the groups and run different predictions for the two things. Okay, but there are a few problems with that as well. One is that it's potentially illegal, okay, depending on what the group is. But even if it's not, or arguably the reason why it could be illegal is because other things can go wrong just as badly. So let's just take a look at a different example. Okay, here the relationship between income and recidivism is identical for the two groups, but the relative proportion of income, right? So basically, the relative distribution of income is different, and that will cause bias in and of itself as well as you look at this group 2, and you can see that some of the members of the group and the lower income, a substantial proportion of them, are basically being harmed by this bias. That's again now it's a function of the fact that you're splitting up the data set. Okay, and sort of an extreme case of that if you're just using the averages, right? Because here, recidivism is the same function independent of the group, but you're basically conflating the two things without controlling for the right things. Okay, so what's the bottom line? Okay, so in fact, data science is actually extremely hard unless you're careful. And the problem partly is that the tools are now so good that it's tempting to think it's easy, right? So you use the tools and without thinking particularly deeply about what assumptions the models make, what assumptions the data that's implicit in the data you've collected, what assumptions you're making when you're using particular measures of quality of fit that you're making, you can get into trouble fairly quickly, especially when it comes out, when the decisions you're making are consequential for people's lives.
Thank you. So I'm going to talk briefly. I'm not going to use any slides, but just want to raise some questions along a little bit of a different axis, and this will be a bit of a lead-in for talk by Professor Igo. So I want to think about some of just how we think about the data that goes into the data science. And there's a lot in the news these days about data quality and privacy. Of course, we've all been hearing about Cambridge Analytica and the dangers that happen as your information that Facebook collects go out to people who may be using them for nefarious purposes. We're also hearing a lot in the news about the question of whether, the issue about whether a question on citizenship should be included in the 2020 census, with a lot of concern by demographers on how this will bias the data collection and lead to potentially significant undercounts, and particularly undercounts of specific identifiable groups, and how this plays out. And I'd like to look at the interaction of these two things. What happens to the people whose data doesn't get collected? So with the census, if we put a citizenship question on, there's a lot of concern founded in empirical work that then a lot of people who either are undocumented immigrants or who simply fear discrimination may not respond to the census or may not respond accurately to the census. We may get big miscounts. This may lead to severe misallocation of federal resources and lack of access to government services by people in vulnerable populations. This doesn't just apply with the census, but more broadly, there can be big problems. Speaking a week or so ago with a colleague who works in medical and health-related geography, I learned that there are issues of great concern around the extent to which mistrust that has arisen, often for extremely good and justifiable reasons, from the misuse of private data, leads members of vulnerable groups to be reluctant to participate in medically related surveys, trials, and studies, which then excludes, again, data from specific groups, particularly vulnerable groups, from being available for being used for beneficial purposes, excluding people we don't know then so much about disease problems, health problems within certain populations, and we don't have empirical data on what are effective responses to help those populations. This being driven by a voluntary, I don't want to participate, I don't trust what you're going to do with the data, which often is founded for good reasons as well. As we move towards smart and connected communities, we're looking towards the proliferation of inexpensive, portable, internet-connected technology. Probably everyone in this room has a cell phone, and it becomes easy to think these are great ways to collect data for really good purposes, to make efficient and effective operation of cities and city services. But it's easy to forget that not everybody has a smartphone. Not everybody can afford a smartphone. Not everybody has a data plan. And so again, whose data is not being collected if we take for granted that everyone carrying around an internet-connected device is a great source of data on how people use city services? And if we shape services around that, how are we potentially denying services to people whose data is not being collected? And we could go on that, but I think I'd just like to kind of set the stage on thinking about this. There are real problems with the data we do collect. There's real problems with the data we don't collect. And there are issues that can come up around the kind of power, privilege, and how much control different people have over what is and isn't collected. Final observation is, with regard to the Cambridge Analytica scandal, there's been a lot of people saying, well, I'm going to get off Facebook. I'm going to get off all these social media, the Facebook, the Gmail, Twitter, etc. And again, it's worth reflecting on the extent to which the ability to say that is a mark of privilege and power. I can afford to go out and pay for a more private mail service than Gmail. I can afford to, and I have the knowledge to set up my own email server, which I can probably get away with because I'm not planning to run for president in the future. And other people are not going to have the money to do this, the knowledge to do this, and the choice of getting off of Facebook, Gmail, Twitter may mean the choice to disconnect themselves from their far-flung family and friends. And we need to think about to what extent this becomes a Hobson's choice that some people are faced with of give up my privacy or give up my connection to the people I love. And being aware of all these and how these choices around data, how questions of what gets collected and what doesn't get collected, and questions of how much control people have are very important for us to think of as we think of what it means to make ethical use of data science. And from our own perspective as people who want to use data and data science for the benefit of humanity, we have a responsibility and we have some power to really try to be rigorous and try to, both in our own practices and in our advocacy, push towards trustworthy use of data, because that public trust that data is being used well, and that public trust must be founded on legitimate confidence, not false security, is going to be really important to the access of data that we want to use to make people's lives better. So I'd like to leave it with that and turn it over to Professor Igo.
Lower the mic. Yeah.
And so if we start,
And
then this is the
okay.
advancer, but it seems to not advance on this screen, but it will advance for you there.
Okay, great. Can people hear me? Yeah, thank you. Great. Well, thanks first to Jonathan for putting together this panel and for wrangling us. and giving us about 5 minutes to talk about a very small topic, data and ethics. Luckily, my colleagues on the panel have already sketched out really quickly and beautifully some of the terrain. So I want to do something maybe just a little bit different, although maybe I'll pick up on a couple of notes that have already come up. Let me just say that I'm a historian, and I've been working for about a decade now, I think, on the history of privacy and privacy debates in the United States since the late 19th century. And that has inevitably, of course, brought me into the history of data and histories of the data bank. And so my comments now will come out of that research. And this is the book that's coming out in a couple weeks, actually, that treats this in much greater detail than I will now. So the scandals and failures around data ethics at our present moment are well known to everybody in this room, whether it's NSA spying or Cambridge Analytica or Equifax or what have you. These are kind of stunning and spectacular episodic events that capture and focus people's attention. But what the longer view, a historical view, has taught me is that, number one, these events should not at all be unexpected, given what we've seen in the past, nor are they necessarily the most important ethics problem before us, in part because they do get a lot of attention, even if that attention then moves on to other things. So the context I just want to sketch out really briefly is that Americans have been grappling for a really long time with data surveillance of one kind or another, whether from the credit industry and corporate powerhouses of one kind or another, or the federal government, or the many different social agencies of the society. Just one figure that might help us here, that I read recently in a great new book on credit surveillance, is that by 1940 already, roughly 70% of the adult US population had their financial lives on record with a credit bureau. So that's 60, almost 70 years ago. Already about 70% of the population had their financial information on file with a private agency. I'm going to show just a couple of slides, and they're really just pictures to give a sense of this history. Let's see if I can do this. There we go. And give you a sense of the long durée of Americans' debates about data and data privacy, and in a way then data ethics. I say the 1910s here, but really starting in the 1890s when fingerprinting comes online as a new technology, debates over who should be fingerprinted, what fingerprint should be used for. This, of course, returns us to Chris Slobogin's talk in some ways, how criminality has been tracked and figured in American society. In the 1930s, the arrival of the Social Security number, which I talked about a little bit earlier today, led to debates about Americans being regimented and tracked by the state through their unique identifying number, which started as one thing, started as a bureaucratic tag, and then became a kind of de facto identifier in the society at large for all kinds of different agencies. And this was not an actual, but a fabricated picture of a dog tag that the Republican opposition to Social Security publicized. By the 1960s, a growing awareness of record systems in American society and the ways that paper records acted as gatekeepers for people's life chances in the society created a whole debate about the power of records and bureaucratic accounts in American life. And then, my last slide, actually, by the 1970s, we get the origins of some of our current debates about computerized data banks and linked records and electronic footprints, and so on. So again, Americans have been grappling with these problems for a long time. They come with what I call a knowing society. A society that seeks to know its citizens, its people better, and also whose citizens want to be known in some contexts better by the agencies of the society. Data has been the lifeblood of 20th century governance of the administrative state, and also a key piece of the infrastructure of advanced capitalism. It's also been, of course, a means to all kinds of modern advances and conveniences, from federal welfare programs and public health campaigns to insights into human psychology and commercial efficiency, better policing, better or not policing, and governance and so on. So it's a really complex and interesting dilemma which does not have easy villains and victims, and this makes the ethical problems, I think, really interesting and challenging. I think it's also this complexity that has made it difficult for Americans to develop a sustained discussion about data ethics. And so in some ways we are belatedly grasping for a data politics that might match our circumstances. So I really just want to make two pretty brief points, and hope that we'll have some time in discussion to talk about them. The first is that the solutions that citizens in the past have come to in order to try to protect their data, make it more secure, create fair information practices, were not, in fact, all that robust, and they're certainly not adequate for the present. I will just tick off some of these solutions. Transparency, access, sovereignty or control, civil liberties, and property rights. I can think of many examples for any of those categories of ways that in American law, regulation, social practices, we have attempted to inscribe certain kinds of rules for how data might be used in fairer, more secure, more private ways that redound, that give benefits to the people from whom those data are collected. And also the failures of each of those kinds of solutions. Transparency has often meant a kind of buffeting of much, much more information that makes it harder for people to understand what's actually happening to their data. The Privacy Act of 1974 is one example. For access, legislation, again, like the Privacy Act of 1974, but also FERPA, which supposedly gave people much more access over their data, did not actually give them much control at all over which data were collected and kept, and also created very cumbersome procedures as well as loopholes for those who hope to get into those files or to duplicate or share them. Sovereignty and control have also been roundly diminished, even as solutions have been put forward, like opt-out policies and so forth. And there are all kinds of critiques of the ways in which sovereignty over one's data has become really implausible in the 21st century. Civil liberties have often been framed as individualistic solutions to what are society-wide problems, and often do not address the kinds of things that Jonathan raised earlier about the kind of power asymmetries in the society that allow some people to exercise those liberties and others not to. And finally, property rights, which kind of always return as a possibility for dealing with data security and privacy issues. The notion that people might be paid micropayments for the uses of their data, for example, or enter risk markets where they compensated for the kind of riskiness in which they are engaged or their data are engaged. Those too tend to be much more limited as solutions to our problems, I think, going forward than they have even been in the past. Data, it seems, are going to be harvested no matter what, unless some other kinds of major structures in the society change. The problems with all of these solutions in some ways is that they've been reactive, they've been drawn from other domains that were not actually created to think about data issues specifically, and they've had a very limited success in either curbing improper or illicit data practices, or in restoring an amount of control or autonomy to people over their data. The second point, which I will make much more briefly, is that I think the focus on spectacular scandals and brazen illegal moves, either by the government or by corporations with regard to people's data, tends to obscure some of the mundane practices that we live with every day, and in fact serves to normalize them in important ways. So some of the practices that have already come up in our panel discussion today, CCTV cameras in all over American cities, cell phone use and tracking, drones, statistical research, the fact that fingerprints and facial recognition scanning, technologies which were once technologies that were fiercely resisted and used only in the criminal justice system, now being used by many of us to open our laptops or get on our phones. These kinds of mundane practices that have moved along without a lot of intention or discussion sometimes or debate get covered over, I think, by some of the more spectacular news that we all know about. And I just wonder about its effect on our norms. And I wonder if this is actually the proper site for us to be thinking about data ethics now. So I'll stop there.
Okay, so now I think we'll have a little bit of discussion among the panel. We'll have a little bit of discussion among the panel, and then I'll open up to Q&A from the audience. So does anyone want to, among us, want to reflect on what we've all been talking about or raise any issues?
Well, there's so many. I think Sarah's point is a very interesting one that we've been struggling. Sarah's point is a very interesting one. We've been struggling with privacy issues for a long time. It's not as if all of a sudden, with the advent of the internet and computers, that this issue's come upon us brand new. It's something that the law's been struggling with for a very long time. I will say that, speaking as a lawyer, and I guess as the person on this panel that represents the courts, the law has been very poor at responding to the kinds of concerns that we've been talking about. The law believes in precedent. The Latin term stare decisis is applied a lot in legal circles. The idea being that we don't want to change things too quickly or too drastically. There are reliance interests. People rely on the current state of affairs. We don't want to surprise people by changing things radically. But of course, the possible downside of that is when you have rapid technological change, as sort of is the premise of this entire conference, the law may be way behind the times. So, for instance, at the Supreme Court level, just now the Supreme Court is starting to struggle with the kinds of issues that I identified in the slide, and as you could tell, in my slides, and as you can tell, up until now, the Supreme Court has pretty much adopted a hands-off attitude towards all the criminal justice techniques that are being used to gather data and analyze it. I think the court is on the verge of changing their position, but it's taken an awful long time. I think one of the defining moments, and I'll stop at this, one of the defining moments in a Supreme Court argument, which I love telling the story about, is when Chief Justice Roberts, in connection with the case having to do with tracking a car using GPS technology, said, wait a minute, you mean they can put one of these things on my car and follow me around? And I think what happened is the justice started realizing, ooh, this could affect us. Not just those scumbags we write about all the time in our opinions. So maybe we better rethink this whole issue.
So I've got a question for you, Chris, is if we think about all of this, and I'm thinking in some ways a little more broadly around Daubert issues with science and expert testimony in criminal cases, and these questions around data science, as Eugene's pointed out, they're very subtle, and there can be very tricky things. So what do you think of in terms of when somebody's brought up and the state brings forward a lot of sophisticated data science and some poor defense attorney, maybe a public defender, is facing all of this, do we need to rethink the way Daubert criteria are applied?
Yeah, just to be clear, Daubert, does everyone here know what Daubert is? Maybe not. It's a Supreme Court decision which has to do with the admissibility of scientific evidence. And it was seen as a sea change in legal analysis. Again, the law is slow to change. Up until Daubert, courts pretty much analyzed scientific testimony in this way. They asked the expert, well, is this something you guys do on a routine basis? And the expert said, yes, it is. Then it was admissible. Okay, but after Daubert, at least the signal from Daubert was, no, the courts actually have to look at the scientific verifiability of evidence. They have to at least pay some attention to error rates, testability, and so on. Now, it's not to say the courts have actually applied Daubert in any serious way in many contexts, but at least there now is this case on the books that directs courts to scientifically investigate what's going on. Judges not being very good at science maybe are a little bit cautious about doing this, but nonetheless they have started to do it. However, in this particular area, the area that I talked about, criminal justice cases where data science is being used, for better, for worse, and I think it's for worse, the courts have adopted a very, let's say, enthusiastic hands-off attitude. A lot of the policing stuff that I was talking about, that comes up not at trial, but at suppression hearings. A suppression hearing is when the defense attorney, the public defender, tries to suppress evidence as illegally seized. Well, the rules of evidence don't typically apply there. Daubert issues are not going to come up, so this kind of data accumulation I was talking about just isn't addressed in any scientific way. Then the other issue I talked about, sentencing, occurs at sentencing. Well, once again, Daubert typically has been held not to apply at sentencing. So even though there are a lot of really interesting technical issues that Eugene flagged, up until very recently, courts have not been looking at this. And so, for instance, you get probably the most sophisticated case to date, Wisconsin versus Loomis, which looks at one of these risk assessment instruments, and basically the court said, you know what, this is just too hard. So just lower courts, be aware that there's some problems here, be cautious, but we don't want to get into the mucky nitty-gritty of numbers, because, you know, we went to law school, we didn't go to medical school. We went to law school because we don't like numbers. I'm being a little facetious and a little bit maybe facile, but not really.
Sarah, Eugene, you.
Well, I was just going to say partly in response to this exchange, is this on? Yes, that's on. That there is this, I feel it's coming still, but it's beginning, right? A discussion about algorithmic ethics or big data ethics or quantitative privacy in some law schools and philosophy departments and things like that. And I'm curious to hear what you all think about what out there suggests that there are some ways that we haven't yet grasped or haven't really been thinking about to really tackle some of these problems, which are deep. I mean, thinking about the kinds of interference that you're suggesting, right, that will get black box like the algorithms, right, that almost nobody can understand, yet are so powerful and so fateful and consequential for people. How do we, I don't know. I feel like these are really tough problems, and I'm curious to know if any of you or anyone out there feels that there are some promising solutions beginning to develop.
Come to the panel next Friday.
We may not learn until Friday, but anything you can reveal now.
I'm not deeply versed in the area of algorithmic ethics, to be fair, but I know there's been a lot of activity in the machine learning community and a great deal of interest in trying to study this. A part of the challenge is actually interference with legal criteria as well, such as whether you're allowed to use certain criteria to get models. I mean, at least in theory, you know, if you understand data deeply, you can tease things out. For example, you would split up the groups. This would allow you to, at least in principle, control for the different relationships that are across groups. Okay, a part of the challenge is, do you trust people to do this honestly and competently? And it's not obvious to me that we should yet. And so that you know, but on the flip side, if you make it illegal to use these criteria in decisions, then you make it impossible to tease that out in many cases. So it is. I have not seen a solution that's compelling yet. The kinds of solutions that I see is people showing, for example, that in the case of like group bias, they show that ex post you can sort of control group bias by looking at sort of how performance differs by group and making sure it's equitable. The problem is it's not obvious that that's legal because, again, you're using group identity in a decision. Even if you do that,